We're back in session again, and I want to really praise all of you who have sat through a whole day, and not because it's so miserable in here, but because it's so nice outside. And I really appreciate that you've thought that this was one of the most important things you could do on a really gorgeous day here in Princeton. Our last panel today is going to explore a somewhat different direction, because the way that we know a lot of these, as much as we know about what the National Security Agency has done, what intelligence services now do, is not just because Ed Snowden took the documents out of the NSA, but because he also gave them to journalists who have had to fight through a process to get them out and get them into print. As you heard this morning when Snowden was interviewed, he wanted to hand the documents off to journalists because he wasn't going to just post them on the web himself. He wanted journalists to do, as he keeps putting it, what journalists do, to check them, to make sure that the disclosures were, to at least give the intelligence community a chance to make the argument about whether the disclosure of these documents was going to harm any operations in process, and to take responsibility for ensuring the integrity of sources, including himself, and to make sure that all of this got out in a responsible way. So this was why he didn't just post everything on a website. He gave these documents to journalists. That said, Snowden's disclosures have occurred in a context in which there's a lot of good investigative journalism going on, but there's investigative journalism going on in a context where the government has taken extraordinary actions against those who leak secured information. Ed Snowden is one of those. As I mentioned this morning, he's facing multiple criminal charges under the Espionage Act and for stealing government property. But other whistleblowers and other leakers have been prosecuted in a really quite extraordinary way. In fact, this administration has prosecuted more intensively and more fully those who have leaked government information than any other prior administration has ever done. So while we may live in an era where there's a lot of information coming out in the press and that brave journalists are undertaking to research and write, it's also the case that their sources, and sometimes the journalists themselves, are really under a threat. So we wanted to organize this panel to look at what's happened to investigative journalism in the area of national security. And so we're going to follow a format in which Bart Gelman will be our lead speaker. You heard him this morning as interviewer, but he gets to talk this afternoon as journalist and as someone who's actually been through all of the Snowden documents and tried to sort out how to publish and how to get all of this stuff out. And then we'll be hearing from two people who have somewhat different experiences. So one is, as we mentioned, well, I'll introduce everybody as we go along. Let me first say, but it's Matt Olsen and Karen Kaiser. But let me first say about Bart that I introduced him this morning. But one of the things that many of you don't know is that he's been a really good friend here at Princeton. He's been teaching here in the Woodrow Wilson School. He's been teaching national security courses, and he's someone that some of the students in the room may have had and may yet have as a chance to have as a professor here at Princeton. As a Princeton alum, we're very glad to welcome him back. I told you about the rest of his bio this morning, so I'm just going to turn over the floor now to Bart Gelman.
Thanks for staying. We're going to be much more fun than those other panels. So I tell stories for a living. I'll start off with a story, which is that 2 years ago, right around this time, I called an old friend at the Washington Post at home at night and said, I need to meet with a new executive editor right away. I had left the Washington Post in 2010 and was doing other things, and I had not met the new editor. He didn't know me from Adam. My friend asked a perfectly reasonable question. He said, why? And I said, I can't say. And he said, come on, I mean, I'm going to look like an idiot. I've barely spent any time with the guy myself. You got to give me something. And I said, well, it's pretty big, and he's going to want to hear it. And by the way, we can't do it in his office because it has glass walls. And he should bring a lawyer. And see, even then, I mean, I knew right away. So 2 days later, I'm sort of slinking up the back stairway of the building, past the 5th floor newsroom, and up to the 7th floor lawyer's suite. And It's Marty's first day back from vacation, and as I said, we've never laid eyes on each other, and here's the pitch that I gave him. I said, I've got a national security source. I've just learned his name. I'm not going to tell you, at least not yet. He's given me extremely sensitive material, stuff that's classified at a level that the Washington Post has never possessed before. I'd been there for a long time, and I knew that to be true. I said there are big, important stories, but also risks. I'm morally certain that at least the first document that I want to write about is authentic, but it's going to be a bitch to verify that and to make sure we understand it in context. And I'll be glad to walk you through the first story, but I'd like to know that you're going to wrap me in the warm embrace of the Washington Post legal department. I did not want to be freelance Bart on this one. I said, you're going to need a secure room and computers that have never touched a network and big safe, and everyone's going to have to learn how to use GPG, and he's sort of starting to glaze over a little bit, and I said, well, don't worry, I've got a list. And I was listening to myself talk, and I thought, this guy's going to throw me out any minute now, because it was sounding a little crazy, even to me. And at one point, because I went one step further, this one I can't spell out exactly, because it is still under privilege, under legal privilege, but I asked him to do something to set my mind at ease, and the partner at Williams & Connolly, who is the chief outside counsel for the Washington Post, and Marty, as the company's lawyer, I cannot advise you to do that. And Marty said, I'm doing it. So now let's move on. And that was a big moment for me, and an indication to me that the Post was still the Post, and it still was willing to take risks on what it thought was a big story. But what do you care? I mean, that's a very charming story on my end. I'm very happy that Marty did that, and I thought the Post has behaved in an exemplary way in the 2 years since. But what can we learn from this? I mean, it's starting to point us in a direction. On the one hand, we can't overgeneralize because the Snowden leaks are sui generis. There's never been anything like it in terms of the volume of very sensitive material. There were more documents leaked by Chelsea Manning to WikiLeaks, but none of them was as sensitive as the least sensitive of the ones in the Snowden archive. And even so, this case illustrates some of the general points I want to make. I wanted a lawyer in the room because, A, I wanted as much of our interaction as possible to be privileged while we figured out what we were doing. And that's because all of us were aware in the room that we were working up against some lines, that there was a remote but plausible case that the newspaper and I, which is what really counted, could be subject to criminal charges if we were to publish this stuff. There's no Official Secrets Act in this country, but since President Nixon and with pronounced increase in number under President Obama, the executive branch has used the Espionage Act as a means of prosecuting disclosure of secret information to the general public. It has been used solely so far against officials or former officials who were cleared to hold the classified information and gave it to someone who was not. But the language of 18 U.S.C. 793 is so broad and opaque, having to do with disclosure of national defense information, that it could be read to do all sorts of mischief against reporters as well. And unfortunately for me, cryptological information and communications intelligence are covered under a narrower and less opaque statute under Section 798. And so we wondered, is it far-fetched to wonder whether this could be the first case in which a news organization is prosecuted criminally for disclosure of classified information? I thought that that was unlikely, and I still do, but keep that mild concern in mind as we move forward about 6 months later. 6 months later, the Director of National Intelligence, James Clapper, gives his first survey, the annual assessment of global threats since the Snowden leaks. It's January of 2014. And the very first thing he mentions is the Snowden leak. And then he paraphrases a story that I had written, and he says the following words. He says, Snowden claims that he's won and that his mission is accomplished. If that's so, I call on him and his accomplices to facilitate the return of the remaining stolen documents. Now, I didn't really hear anything after the word accomplices, because accomplices has a legal meaning. And this was not an off-the-cuff remark. The kind of testimony is written and circulated in advance all around the executive branch, vetted, argued about, refined, and here it is appearing in the testimony as he states it. And it wasn't the only case. The NSA's Inspector General, who's a perfectly nice guy I've spent some time with, on this campus, has twice used the word collaborator, and I think once co-conspirator to refer to the reporters. 2 of those times I was in the room when he said it. Even so, then and now, the more realistic threat was civil compulsion. So Snowden was going to be charged with crimes, clearly, and he soon was. And the crimes would consist of giving information that he was not allowed to give to me and to 3 other reporters. And it's not far-fetched to suppose that our notes and testimony, even if he comes out and says, I did it, are going to be desirable in terms as the prosecution sees it. And I had to give a lot of thought to how far I would go in resisting a request or a demand for that kind of information, and I did give a lot of thought to it, and I talked to Snowden about it in advance. Now, as this is happening, James Risen of the New York Times is in the advanced stages of fighting and losing a series of court orders that require him to identify his source and turn over notes. And he is getting closer to the day when he faces a very good prospect of being jailed for contempt. Now, I wanted to be the only person who had the power of decision about whether to comply. One reason for that is that at Time magazine in the mid-2000s, the magazine had turned over a reporter's notes to a special prosecutor against the will of the reporter. And since that time, and actually a little before that time, back when I was still on staff at the Washington Post, I had not kept any of my notes in a form that anyone at the Washington Post could read. I had learned early on the encryption tools, and I was not interested in having my stuff on a network. And for the same reason, and also for very important security reasons, I thought I did not allow anyone at the Post to have full access to my notes or to any of the Snowden documents without me. I've turned over small amounts at a time selected by me when I wanted to collaborate on a story with them, but nobody's been able to browse around. So 6 weeks after the first Snowden stories, I find myself at a conference with a guy named Neil McBride, friend of Matt's, and someone I'd seen once or twice before at other conferences. He was then the U.S. Attorney for the Eastern District of Virginia. He was the one who was trying to compel Risen to testify, and he was the one who had filed the charges against Snowden. And we're in a very big space, and he sees me across a very big room, and I see him, he sees me, and he starts walking straight toward me. And he walks all the way across, and he kind of, tall guy, looks down at me, doesn't say anything, and then he finally says, will you autograph my copy of your book? So he was obviously trolling me a little bit here, but there was something unspoken here. I mean, we both knew it was possible that we might meet under other circumstances, and I had lunch with him the other day, and he said that he would not have hesitated to file a contempt request if he were still the prosecutor and he thought he needed the testimony. He said it would be in the spirit of Michael Corleone, not Sonny, nothing personal, only business. So I'm not going to whine a whole lot about poor me, right? The much greater risk in this country when it comes to national security reporting is to the sources of unauthorized disclosures. Now, you don't have to get anywhere near classified information to be very much at risk if you are an unauthorized disclosure. Now, classified and unclassified stuff is leaked all the time, hundreds of times a year in Washington. by people who represent or believe they represent the interests of the government of the day. I mean, so, you know, I've had an assistant secretary of a large department in the past just openly hand me something that had a stamp on it because he wanted to show me that his version of reality was correct, and carefully selected, I'm sure, as well. But I mean, there's a term for this in the recent legal literature on it. It's called pleaks. It's a plant/leak, and it is on behalf of and fundamentally approved by the government of the day. But the people who leak information that is unfavorable, that is critical, that and especially that could thwart the government of the day from doing what it wants to do are very much more at risk. That's whether or not it's classified. That doesn't mean they'll be charged with espionage, but you know, I've very seldom met a whistleblower who was identified and his life was not, or her life was not just ruined by it, certainly career-wise. When it comes to the classified stuff, I had a big problem when dealing with the Snowden archive. I could not take for granted that the documents were authentic, and I could not take for granted that even if authentic, that they were accurately stating facts of the world. I mean, there are authentic documents in this world that are full of crap. And so the normal thing a reporter would do to authenticate and understand the context of something would be to talk to other people about it, talk to people you know have expertise. And I'm in a position now in which I could be putting other people at very considerable risk. And it's hard to even get consent for that risk without putting them at risk. And so I would have these strange conversations with people where I would sort of, I would drive to their homes in a car that didn't belong to me, that didn't have GPS, without my phone, and knock on the door, make a little small talk, and say, supposing a reporter one day knew some stuff he shouldn't know about the way this and that thing operates, would you want to know that, or would you say, get out of my house right now? And that was the best I could come up with, and I kind of got both answers over the course of the past 2 years in various forms, some more polite than others. The paradox was that the very surveillance programs that I wanted to write about put my ability to do my work at risk. And unless I took extraordinary precautions, it was going to be very difficult for me to protect who I was talking to and what they said, even if I used the best available tools of anonymity and encryption. I'm very grateful to say that some of the people who wrote those very best available tools are in this room, for which I say thank you. I mean, if I didn't know how to use Tor, or GPG, or Jabber with off-the-record encryption, I would not have been able to talk to Snowden. And it's rather remarkable that he could have done what he was doing. You see, he was taking large quantities of classified information that he was not supposed to be able to take, and while doing that was also in communication with multiple reporters. So when he says encryption works, in that sense, it's clearly true. So here are a few points of context for the thing I want to talk about here. It is possible, and Peter Gallison at Harvard has reported it's a fact, that there is almost certainly more classified information on planet Earth than unclassified. That the volume of classified information is so immense, it's actually kind of hard, it's hard to wrap your mind around it. Certainly, I've never spoken to anybody inside the secret world, and I'll be surprised if Matt contradicts this, who wouldn't say that there's a massive amount of overclassification, that much more is classified than it should be. I have been, for a lot of years, writing about defense or intelligence or foreign policy, and the fact is that almost everything you want to know as a reporter on that, and almost anything you want to know as a reader on that, has a very good chance of being classified. If it was not in the congressional briefing, in the press release, in the public speech, in the news conference, it's very likely to be classified. And that's taking on a lot of power for the government to filter out what we're allowed to know about what it's doing. So some of it clearly is for good reasons of security. And some of it sort of obviously isn't, and is just sort of silly, like the classified Navy laundry manual, which I'm not making up. And some of it is very interesting when you analyze it. So here's one example from the Snowden papers. He referred to it very briefly this morning. There was a report I wrote about that said that over the course of a year, the NSA had what they call compliance incidents, or breaches of rules, breaches of privacy rules that are legally binding, over the course of 1 year, 2,776 times. You could look at that a lot of different ways, and I tried to be thoughtful about it in the story. And certainly as a percentage of the amount of data they collect, that's pretty small. But that's not an argument that anybody at the NSA wanted to make. Well, you think that's a lot? Well, you should see what we're collecting. The point is that number in the internal reports was classified secret. That's actually quite a low level of classification for the NSA. It's almost, that's practically like the lunchroom menu over their secret. When they reported these same numbers to Congress, they were classified top secret / special intelligence, which meant there were compartmented information, which also meant that fewer than 1 in 10 members of Congress had anyone on their staff who was cleared to read it, which meant only the member, him or herself, could read it. They'd have to go into a SCIF, a secure compartmented information facility, by themselves, read through a pile of documents, not allowed to take any notes, and not allowed to take anything out with them, and not allowed to talk to their staff about what it means when they come out. I can't say what the purpose of the change of classification was in that case, but I can tell you that the effect is very much to reduce the possibilities for accountability. Now, 2 recent episodes were very much on our minds when I first sat down with the Washington Post's editors and lawyers. One was that the Justice Department had secretly subpoenaed the telephone records. It was a subpoena, not a search warrant? Yeah, subpoena, secretly subpoenaed the telephone records at the AP during a leak investigation in such a way that had the effect of getting the records of, I think it's accurate to say, every reporter and editor in the AP's Washington bureau for some period of time.
And New York.
And New York. So that's a lot of records about a lot of subjects and potential to expose a lot of confidential conversations. And because the subpoena was issued in secret, it meant the AP had no opportunity to contest it and no opportunity to tell the judge, that seems a little broad. I mean, even our fallback argument, if you do insist on issuing a subpoena, would be, let's not do it for everyone in Washington and New York when you're investigating one story. In another leak probe, the FBI had obtained telephone and email records for James Rosen of Fox News. And in that case, the FBI got its legal authority after providing an affidavit that said that Rosen, the reporter, was at least an aider and abetter of the alleged crime, if not a co-conspirator. So there are things we can measure and things we can't when we want to think about the impact of this sort of aggressive legal posture on the kind of reporting I want to do. So here's an academic study published in, I think, the Michigan Law Review. Between 2001 and 2006, the number of subpoenas to news organizations more than doubled to 7,244. Of those in 2006, about half, 3,000 or so, were federal subpoenas. Another important difference, in 2001, only 2 out of all those subpoenas demanded to know the identity of a confidential source. In 2006, it was 43. And the number was still growing at the time that I was doing this work. And then there's the subjective part that many reporters, myself included, have noticed that people in government are a lot more reluctant to talk to us, or a lot more worried about talking to us, even about matters that clearly are unclassified. And they have reason. After the Snowden stories began, Director Clapper, the Director of National Intelligence, issued Intelligence Community Directive 119, binding on everyone who worked for any of the 16 intelligence agencies, which said that they henceforth could discuss, that they were not allowed to discuss any quote-unquote intelligence-related information explicitly, whether classified or not classified, with a member of the news media without prior written authorization. And, if they accidentally, the words are unplanned or unintentional contact with a member of the news media, they had to report that contact, and those reports were going to be archived and maintained for every employee, any kind of contacts with news media. It's clear that they're interested in detecting and monitoring and cutting off contacts that could lead to conversations down the road that would cause a loss of national security information. That's the ostensible and to some extent the honest purpose of it. But it clearly also has the effect and probably the intent of ensuring that only the authorized version of the fact that the only news released by the U.S. government would be the authorized news, would be the news shaped by the people at the top. So at the same time, most departments of the federal government, including agriculture, were issuing new guidelines to prevent insider threats. So the agriculture training manual, I'm not making this up, was called Treason 101. The Department of Education said that people should be on the lookout for coworkers who had certain life experiences that could turn them into spies, such as, quote, stress, divorce, financial problems, or frustration with coworkers. I was going to ask for a show of hands, but I don't want to put you at any kind of risk here. So now you can imagine the chilling effect that this does have with any sort of normal contact with news media. So meanwhile, now and then, while we were working on the Snowden stories, and actually early on before the first one ran, Marty Barron, the editor of the Washington Post, would excuse himself, and somebody said he had to go to a meeting with the Attorney General. And I said, what? And it turned out that Attorney General Holder had promised after the AP and the Fox cases that he would impose greater restrictions, new guidelines, on use of investigative tools against the news media. And he had a group going to consult about what this should look like. I believe Karen was on the group as well. And the only thing I could think of to tell him was he better hurry. I thought the atmosphere might be different pretty soon. The new guidelines did come out, even post-Snowden, and they're an improvement. The department promised that there would be advance notice of subpoenas like the one the AP received, or not the AP received, the one that the AP was the target of. Advance notice would be the norm, and it could only be overridden by the Attorney General personally, and only if there was a substantial threat to the investigation, or that he believed that there would be great harm to national security or imminent risk of death if the subpoena was disclosed in advance. That sounds pretty good. That sounds like a pretty good standard. He also said reporters would not be prosecuted criminally, quote, solely for news gathering activities. Now, the word solely is sort of interesting here. It means that news gathering activities actually can form part of the predicate for an indictment. Maybe even a large part, as long as there's something else going along with that. And depending on the interpretation, could be a pretty big loophole, especially because one of the crimes that the DOJ investigates in leak cases is, quote, the receipt, possession, or communication of information relating to the national defense. I believe Holder was sincere. I believe that there is not going to be a prosecution of a journalist based on these guidelines under his watch. But there's enough wiggle room to be concerned about down the road. I mean, the big trouble, as I see it, is the warping of the Espionage Act over the last few decades, and in an accelerating way in the past few years, into a general criminal ban on unauthorized disclosure. So, I mean, if you treat talking to a reporter as spying and tantamount to selling secrets to the FSB, then the investigation becomes a counterintelligence investigation as well as a criminal one. And counterintelligence investigations trigger the authorized use of much more intrusive tools. It turns out that these Justice Department guidelines do not, as far as the Justice Department sees it, cover the use of national security letters or FISA warrants. So while the DOJ has promised to release reports on the numbers of times that it uses the usual tools in an Article III court to obtain reporters' records, it will say nothing about whether anyone in this room has been subject to an NSL or to a FISA warrant. And when you treat talking to a source as a kind of espionage, potentially, certainly on their part, then you force reporters to try to learn how to behave more like spies. We have to do a lot more, spend a lot more time and effort to cover our tracks because it's so much easier now to use electronic means to ascertain who I'm talking to. I have to make a conscious choice to leave my phone somewhere and how do you even arrange to have the meeting and how do we have first contact and so on. Even though I say all this, I am not nearly as much an alarmist as some of my colleagues are. There are people who talk about a kind of an oppressive regime and that these are sort of the end days of investigative journalism. And I think it's hard to argue that this is the worst of all worlds for national security reporting, given that there is so much really good work still being done. I mean, we have found out in recent years about secret prisons and warrantless surveillance and drone killings and the nature of no-fly lists and torture and detention policies and dozens of other powerful and important stories. Some sources are frightened by the new atmosphere. Some are inspired, actually, or it breaks the camel's back and they decide they actually want to go public. There are better security tools to protect our communications, and they're getting easier to use, though still not nearly easy enough. Although modern technology can help the government quite a bit in its investigations, it's also true that large volumes of data can be sort of copied and transmitted almost instantly and at near zero cost, and in appropriate cases, crowd analyzed by people all over the world. And I really don't know how to weigh the overall balance. I think the US government has a lot of coercive power. It is using that power somewhat more aggressively than it used to, but it is hardly doing all it could, even under current law, to crush unauthorized leaks. There is a legal and political culture in this country that far more than black letter law is protecting what I do. If people had come into my office and seized my documents and charged me with a crime or put me in jail if I wouldn't testify about it, I think that would not go over well amid a national and international debate about whether the US government had been acting appropriately and drawing the right boundaries in its surveillance programs before disclosure. I think that there's a very, very high threshold in this country, much higher than in almost any other country, for using that kind of really aggressive legal response. I'm a lot safer doing it here, for example, than I would be in the UK. So I am genuinely concerned about some of the developments and about the potential of other ones. But I do notice that I'm sitting here at Princeton freely talking about this subject, and nobody with a badge has arrived to put me in cuffs. Depending on your point of view, you could call that progress. Thank you.
Great, thank you. Our next speaker on this panel is Matthew Olsen, who from 2011 to 2014 was director of the National Counterterrorism Center. Before that, he was general counsel of the NSA. Even the NSA needs a general counsel. Before that, he was head of the Guantanamo Review Task Force. He's also served as Deputy Attorney General and Assistant Attorney General in the National Security Division. And as I was looking through his bio, I discovered one thing I really felt I needed to mention also, which was that he's not only a graduate of Harvard Law School, but when he was there, he served as the executive editor of the Civil Rights and Civil Liberties Law Review. And so with that,
Thank you for saying that. I really do appreciate you bringing that out. I would not have felt comfortable necessarily. So self-serving to say that, and it's more than a couple years ago. So let me also begin with a personal point, as Bart did. First of all, Bart and I are going to have a fair amount of common ground, given his comments and what I want to say. But at a personal level, and I graduated from law school, from college. My first job was as a news aide at the Washington Post. I took a year off and I worked there for a year. I really wanted to be Bob Woodward, if not Bart Gellman, actually. That was 19, yeah. Actually, unfortunately, I kind of wimped out in retrospect because I realized it was really hard to be a reporter at the Washington Post. You couldn't just apply and be a reporter in the newsroom at the Washington Post, it seemed to me, and I went to law school like you did, because it seemed like an easier path. But then I became a prosecutor, and I spent 10 years as a prosecutor in the U.S. Attorney's Office in Washington, D.C., where I did mostly street crimes. And I thought, in retrospect, that's about as close as you can be as a lawyer to being a reporter. You gather facts, you protect your sources, you try to figure out a way to tell a compelling story to a jury. But it's very much like being a reporter. So as I said, I think fair amount of common ground with what Bart said. I'm not going to comment on specific cases having just come out of government. I'm not in government anymore, but I left just in November, so I'm fresh enough out that I'm kind of uncomfortable talking about specific cases, although I will mention things that are in the press. But at a higher level, there's I think we're all basically in agreement on a couple things. I mean, and that there are really core values at stake. And Bart, you've talked eloquently about this. One of those vital core values is that as Americans, we believe in a free press, and we believe that a free press is absolutely essential to the functioning of our democracy and an open society and self-governance. The other core value is that as Americans, we believe that the government's job is to protect us, to provide security, to protect us from foreign threats, to protect us from criminals. And that's a core function of the government. And those core values, for the most part, are congruent and don't conflict, almost all the time. But sometimes, and Bart lives at this intersection, and I suppose you do too as well, Karen, is that they do conflict and they do collide. So the question is, given that common ground, given those core values that we believe in as Americans, and the times when they conflict, which is what's so interesting about having a discussion like this, how do we resolve those? How do we think about the ways to reconcile the conflict that sometimes does occur? And the first way I think about it is a couple of process points. And one is the formal process that Bart referred to, and that's the way the Department of Justice resolves the issue of having to investigate either a leak or some type of criminal activity where it's possible that a reporter has information about that activity. And there are rules in place that have been around for a long time, but they were revised most recently, I guess just last year and then into this year, that Bart referred to, that are now regulations that apply to every prosecutor, every investigation that the Department of Justice does when you want to use any criminal tool, subpoena, search warrant, for information that's in the possession of a reporter. A couple things that I think are important to realize about those rules. One is that when you want to use a subpoena, when you want to get information from a reporter, the Attorney General, him or herself, has to approve that. It has to go to the Attorney General, and she has to approve it in writing. It has to be as a last resort. You have to exhaust all other means to get that information. And you have to show as a prosecutor that obtaining that information is essential to the effective prosecution of your case. So it can't just be helpful or interesting. A subpoena is a relatively low threshold, so you have to actually show that it's essential. So all the ways in which reporters are protected in terms of a process from intrusive government techniques that are used typically in criminal cases. The New York Times said when the new rules came out that the new rules, quote, offer journalists more protection from government intrusion than ever before. So while it may not be ideal, and there may be ways that folks could think of ways to improve it, journalists could think of ways to improve these rules, I don't think it's the case that we're in a worse place than we were. I think, in other words, I don't think some of the more extreme views about the way the government has gone after information that reporters have are actually accurate. I think the rules are more protective than they've ever been. In fact, that's what the New York Times said. So that's a formal way that we resolve that collision between those two core values, between a free press and national security. Another way is informal. And again, I'll just say, I know that Bart's been involved in this as much as anyone, and that is the give and take that occurs typically between editors and national security officials when there is a matter that the press wants to report, and they call the government, and the government gets on the phone with the editors, and I've been involved in this a number of times myself, and there's a discussion about what the reporter has, what the newspaper has, what the reasons are that the government doesn't want that published, why that would be harmful. And I've been involved in a number of cases where That has resulted in newspapers not publishing because the case was made effectively and sufficiently that it was a matter that would really be harmful to people and to American interests.
Like whole stories?
Not whole stories. No, I should be careful. Not whole stories, pieces or facts or bits of stories. I don't know if I've ever been involved in. There may be cases where whole stories were withheld. I'm sure I've read about cases where whole stories were involved, were withheld, but I have not personally been involved in those. So that's that's an informal way, and that's another way that those two values, when they collide, are reconciled, right? That information is taken out, bits and pieces are withheld, and it's actually, I think, overall, it's a rough and tumble way of compromising, but it's been effective in my experience. So let me just give you a couple of examples then more concretely of how this works in my experience, and then I'll turn it over to Karen. So one is relatively mundane, but I think it's somewhat illustrative. And this is just as a prosecutor. I say mundane because it doesn't involve, NSA surveillance. It actually involves a murder, a triple murder. And when I was a prosecutor in Washington, D.C., I had a case involving a triple murder in Northwest Washington. One night, 2 guys with guns came in and shot up people in a crowd, killed 3. They got away in a getaway car. And that night on the 11 o'clock news, there was a guy being interviewed by a reporter on the news saying that he saw someone duck down near a sewer, run away from the scene, duck down near the sewer. Police went to, this is a longer story than I'm making it, but the police went to the sewer, found a gun, matched the murder weapon. And we didn't know anything about this guy other than that he was on his face on TV. So we went to the news station and ultimately had to get a subpoena. We had to go through the process and get a subpoena for the notes from the reporter and the unshown video, the video that was left off the TV. That ultimately led us to this individual who ultimately testified in the grand jury and at trial. It seems mundane, but this guy did not want to testify. He was a source. He maybe, I don't know if he was drawn to the lure of the camera and talked on TV, but he did not want to testify against 2 guys, in kind of a gang-style triple murder. His testimony was absolutely essential to our success in that case. And that's a case where I think, we went through the process worked, we got the information, and we got a result, right, that helped protect, if not the country, at least that neighborhood going forward. We probably never would have found him without our ability to subpoena that reporter, that news station, and get those notes that helped us find that individual. I say it's mundane, but I do think it's illustrative of the way a lot of this works and way these issues are reconciled. The second one is a bigger deal, and that involved a matter that I was at least involved in when I was at the National Counterterrorism Center. I was the director there the last 3 years, and it involved a bomb that was made in Yemen by members of the affiliate of Al-Qaeda in the Arabian Peninsula, that was destined to be put onto an airplane bound to the United States so that it would blow up a plane. That case was disrupted, that plot was disrupted, and an FBI bomb technician leaked to the press that the FBI had that bomb, the actual bomb that was destined for that plane, at its lab in Quantico, Virginia. That technician ultimately pled guilty to leaking that information and was sentenced to 3 years in prison. He was identified as a suspect in the case after toll records for phone numbers related to a reporter were obtained through a subpoena. So again, bomb technician, FBI, leaks to the press that a bomb that AQAP made was at FBI lab in Quantico. Only after toll records showed that bomb technician was in touch with a reporter was he ultimately identified as a suspect. He was then prosecuted and pled guilty in 3 years in prison. So I wasn't involved in the subpoena side of that, the prosecution side of that. I was at NCTC. No doubt in my mind that was a real case. In other words, that was a big deal for AQAP, the group in Yemen. They were trying to put a bomb on a plane. They've been trying to do that for a couple of years. This is really the 3rd time in 5 years they've tried. I'm not sure. I mentioned the sort of give and take that takes place. I don't know anything about whether that happened in this instance, whether it was a give and take between the reporter and the government to say, don't publish that fact. I'll say this, that as the Deputy Attorney General said after the plea, that the leak severely jeopardized national security and put lives at risk. So that's a quote from the Deputy Attorney General, definitely consistent with my view. That leak jeopardized national security and put lives at risk. So, to me, a big deal. So, I think this is the last thing I'll touch on, and that is, given those two instances, given the effort to resolve this conflict, a question that I think that groups like this, that forums like this, are really useful at addressing is, what is the right standard? So, Bart, I'll go back to something you've said, because I look back over some of your comments, which, what is the right standard, and when will a reporter not publish? And one way to think about that is that a reporter won't publish a secret that puts lives at concrete and immediate risk. I think the hard question is whether that standard is too demanding. So you think about it, concrete and immediate risk. So what about just if you take away those modifiers, concrete and immediate? It will put lives at risk, or it will put lives at risk, maybe not immediately, but at some point in the future that's indeterminate. How do you think about that, particularly in the context of surveillance capabilities that aren't really focused on a particular case or a particular source, but degrade our ability to follow terrorists overseas because of those leaks? Is that standard concrete and immediate risk, put lives at concrete and immediate risk, is that too high of a standard? And I think that that's a really hard question. So I'll leave it at that. I mean, I do think that, as I said, forums like this and opportunities to talk about this are really useful. I think there is a lot of common ground, and it's very important that we continue to have this discussion to think about how we resolve what does sometimes conflict between these two sort of core values for us as Americans. So thank you very much.
Terrific. Our third panelist today is Karen Kaiser, who is the Senior Vice President and General Counsel of the Associated Press. She was deeply involved, as Bart noted, in this secret subpoena process that asked for AP phone records, and she helped to negotiate the new DOJ guidelines on these questions. Before joining the Associated Press, Karen was Senior Counsel at the Tribune Company. She also was instrumental in passing the Connecticut Reporters' Shield Law. And earlier on in her career, she worked for the New York law firm of Cahill, Gordon, and Reindel, where, among other things, she handled the Valerie Plame CIA leak case. So we're really grateful to have her with us. I also want to make one other comment, which is some of you might have seen that advanced publicity in which Jill Abramson was supposed to be on the panel, and she was called away Thursday on a family emergency. So not only are we really grateful that Karen is here with her expertise, but we're also especially grateful that she agreed to come on Thursday for a thing on Saturday. So thank you very much, Karen, and
Thank you.
over to you.
Thank you. My pleasure to be here. Thank you, Bart, for inviting me. So there's a lot that I want to say, really, and a lot of it echoes what Bart said, and a lot of common ground that we can share as well. I will say first to start that I agree that there is an inherent conflict. There are many core values at stake, and they're all important. But there is a necessary tension between the press and the government, and it's going to be that way because the press's role is to shine a light on the government's activities. And the government has a lot of secrets, probably too many secrets, as Bart explained. So there will always be that tension. And there needs to be a respect for the First Amendment during that tension and its role to inform the people. Otherwise, we really lose an important aspect of our democracy. And I will get to the guidelines in a moment, but I do want to say the second example that you gave is the AP story, as I'm sure you know. And I'll give some background on it, but just to start, I will say that there was that give and take discussion during the right before the AP story was published. And as noted in our story, AP held off publishing for 5 days because we were told that a sensitive security operation was underway. And it was only after AP was assured that there were no more security risks of the ones that they told us that we went ahead and published. So there was that particular give and take that you mentioned. Just going back and letting you know a little bit more about the AP story and the subpoena that followed. So the AP story was published in May of 2012. And as Matt noted, it concerned a story about a foiled bomb plot. Al-Qaeda in the Arabian Peninsula was planning to use a new and sophisticated bomb to destroy an airliner that was headed to the U.S. And the AP story revealed that the CIA had thwarted that attack, which was intended, by the way, to coincide with the one-year anniversary of the killing of Osama bin Laden. So the story was very important on its own merits, but it also called into question a statement that was made by the White House press secretary just 2 weeks prior, that there was no credible information that any terrorist organizations were planning or plotting any attacks against the U.S. to coincide with bin Laden's death. So as you can see, that contradicted what the information that AP had found out. So AP did meet with the government. We did hold the report, like I said, for 5 days, based on a sensitive security operation that was underway. And only after we received assurances, we went ahead and published. So this story received very widespread attention, as you can imagine, and a leak investigation was started just days after, and a special counsel was appointed just a month later to investigate the source of the leak. And we heard nothing further for about a year, until May of 2013, when we received a letter informing us that the DOJ had secretly subpoenaed our telephone toll records. They took a total of 21 phone lines belonging to 7 journalists, home, cell, and work numbers, but they also took main switchboard numbers for New York, Washington, D.C., and Hartford, Connecticut. And it was our assessment that at least 100 journalists were implicated by that, and their telephone toll records were captured in that taking. I mean, thousands upon thousands of phone records were taken, and it included the toll records, the ingoing and outgoing calls, dates and timestamps for those calls, and also for text messages. And importantly, as Bart noted, all of this happened without any notice to AP prior to the taking, so we had no opportunity to challenge it in court and make the case that this was completely overbroad and not justified. And the DOJ claimed that an exception applied to this rule, to the notice rule, and that was that notice can be circumvented if it would substantially impair an investigation. But what was troubling about this was that the investigation was already public. So their argument was that the leaker, the source, would find out that they were after the source by virtue of making known that they subpoenaed AP. Again, it made no sense because the fact that the investigation was already public. A U.S. attorney was already appointed to lead the investigation. It had been going on for a year. So according to that argument, it just wasn't tenable. And in that case, you can say it applies really to any investigation. So we were placed in a very bad position. I will say that right at that same time when that happened, we learned about Fox News reporter James Rosen and the affidavit that the government had written labeling him a co-conspirator of the Espionage Act. And the way that also came about was very troubling. The DOJ wanted his emails, and according to the Electronic Communications Privacy Act, you cannot obtain emails that are less than 6 months, that are less than 6 months old without a search warrant. But under the PPA, the Privacy Protection Act, you cannot use a search warrant against a member of the press unless you have reason to believe that person is a suspect of a particular crime, including the Espionage Act. So they filed an affidavit labeling him a co-conspirator of the Espionage Act in order to obtain his emails. So it's a little technical, but that was the reason for it. Now, the government said it had no intention to actually prosecute Rosen, but that really made no difference because the affidavit was already out there. And as Bart said, there's an enormous culture of intimidation, and I like to talk about that when I put this in context, because in addition to the AP and the Fox matter, there were 8 leak investigations in this administration alone, more than all other administrations combined.
I think you mean prosecutions.
Prosecutions, yes, yeah. You're right, prosecutions. The government at the same time was arguing strenuously in the Fourth Circuit against the reporter's privilege in the Jim Risen case. So that was happening all along the same time, and by the way, the Fourth Circuit at the end eviscerated the privilege. The Insider Threat Program was another troubling development. The Directive 119 was yet another one. The statements of DNI, of Clapper, the DNI statements, were also yet another troubling addition to what was becoming a real culture of intimidation. So that's the bad scene. The good that came out of it were the revised guidelines, and I'll just talk about those for a few moments. I was part of the initial group that met with the Attorney General Because what happened was President Obama asked the Attorney General to convene a series of meetings after the whole AP and Fox News revelation, to convene a series of meetings to discuss the guidelines and how they can be improved. So he met with academics, he met with practitioners, First Amendment lawyers, and so forth. And two sets of revisions came out of those meetings. One that happened in 2014, and a second revision to the guidelines that occurred early this year in 2015. And it is quite good. The result of it is very strong. So in the first set of revisions, in the 2014 revisions, what they did was they tightened the presumption of notice. So beforehand, there was sort of a backwards notice presumption saying that notice would only be given if there wasn't a threat to an investigation. Now notice must be given to a news agency unless there's a compelling reason to believe for that a clear and substantial threat would be posed to the integrity of an investigation. So it flipped the presumption to one of notice, and it upped the standard. It closed that suspect exception loophole that existed at the time that allowed James Rosen to be accused as a co-conspirator in an affidavit. It expanded the guidelines to all forms of communication, not just telephone toll records, but emails and other communications as well. And it really upped the standards substantively and procedurally. But what happened was in 2014, when these guidelines came out, they contained some new and troubling wording that didn't exist before. So news gathering was now suddenly defined as ordinary news gathering. There was, without any explanation of what ordinary meant and what would constitute ordinary news gathering and what wouldn't. So would receiving classified information be ordinary or would it not be ordinary? And that was a troubling development in the guidelines.
In fact, could I just clarify?
Sure.
Didn't they say in the Rosen case that
point.
his use of pseudonymous email accounts, I mean, it was pathetic operational security. It was, equivalent of just saying, I'm Donald Duck at Gmail and not taking any other security measure. But the fact that he had little code words and pseudonyms, that indicated knowledge that he was doing something wrong.
Exactly. If you read the affidavit, it's really troubling because the basis that they used to claim that he was a co-conspirator, it was just, there was nothing about it that was out of the ordinary. I mean, they said that he employed flattery techniques to try to appeal to his source, and that was one of the bases. So it was a very troubling
There were
affidavit.
question marks in his emails, right?
Right, exactly. So the use of the word ordinary in the guidelines was very troubling, and there were a few other inconsistencies and items that we were unhappy with. So we went back to the Attorney General in 2014, and I'm part of a task force that meets with the DOJ regularly. It's a task force of about 8 journalists and 3 lawyers. And we went back to the Attorney General, and over the course of 2014, we met with the DOJ several times to try to improve the 2014 guidelines with some stronger protections. And it finally came out in, I think, the end of 14, early 2015. And the second round of improvements are very strong. So they took out the word ordinary from the guidelines, and now it just refers to news gathering, which I think is the biggest benefit of it. They also clarified what was in the 2014 guidelines and meant to be an extra hurdle, an extra step, but it wasn't that clear. But they clarified a new D&I certification. So the Director of National Intelligence would have to certify a continuing need for a certain leaks prosecution. They added an additional level of review and meeting before moving to compel a source to comply with to compel a reporter to comply with the subpoena. And they added some safeguards as well. So I think what we have now truly is a much stronger protection than we had about a year ago. But I will say the guidelines, as good as they are now, they are just guidelines. If the Attorney General decides to bypass notice, these are not enforceable. You can't go to court and bring a cause of action for failure to comply with the guidelines. So there's more that can be done. There are shield law discussions that can probably take place here. I'll stop right now because there's a lot more to talk about.
Great, thank you. So we have a little time for questions from the audience. Julian, and actually, we have that Joanna is breaking speed records. Okay.
Thanks. Julian Sanchez with the Cato Institute. So one of the sort of conspicuous carve-outs in the DIOG guidelines for obtaining press records is that and I think this is true of the revised ones as well, they cover grand jury subpoenas, but explicitly carve out records obtained via national security letter. And we know there's at least one case in which the FBI got dinged by the Inspector General for essentially putting in a request for a 215 order, getting shot down by the FISC on First Amendment grounds, and then going and getting national security letters for the same journalist records. It seems as though often in the kind of case we're talking about, which is to say leaks of national security information, if the national security authorities, letter authorities could plausibly be used, and are much more likely to be used if you have lighter restrictions, or restrictions that apply on getting the records by other methods and not via NSL. I'm just wondering whether people think that perhaps it would make sense to provide some uniformity so that the protections on press records would apply regardless of the specific mechanism.
It would absolutely make sense, and we did ask for it. And our argument was that the same principle should apply no matter what the legal mechanism or legal process is used. And we specifically said NSLs were important to put into the guidelines. We were not successful at that, but it's part of our continuing topic that we're raising. The task force still meets with the Attorney General, and we plan to meet with the new Attorney General, hopefully as soon as she's able, and that's #1 item on our agenda.
Let me just make sure everybody understands, because you know, but not everyone in the room may know. A national security letter is a letter issued on the authority of the FBI itself. It does not need a judge. It doesn't need an official of the Justice Department. It has internal standards. But essentially, your special agent in charge issues the letter. It's when you want it, it compels the recipient, phone company, for example, to provide records about the subject, like Bart, for example. And the rule is that the recipient of this letter, the phone company, is told, you may never, in perpetuity, tell anyone, including Bart, that his records were obtained this way. And there's actually no review at all other than the internal review at the FBI. There was one time, I will say, after a long story I wrote in the Washington Post, there was an Inspector General's investigation, and they did find that they'd improperly used an NSL to get records of my colleague, Gelman Nagashima. But we have no idea whether they're using them now. And I'd actually be interested in whether you have a view, Matt, on why they should be treated differently from subpoenas and warrants of other kinds.
I just whispered to Karen because about that. It's not apparent to me why it would be treated differently. There might be, I haven't been directly involved in these discussions, but at least on the surface, it's not apparent to me.
This is Catherine Hawkins from OpenTheGovernment.org. It occurred to me that one advantage to reporters of them relying on the national security authorities is they tend to hesitate to introduce records obtained that way in court because it invites court review of programs they don't want courts to be able to review generally. But given what would stop someone from using national security letters or some other form of classified counterintelligence investigation on a reporter's records and then finding out who the source is and subpoenaing the source's records?
Nothing, that's the purpose.
Actually, I'll do this. Here.
Hi, Adam Langley. What security procedures has the AP implemented since you failed your bomb threat source?
I'm sorry?
What security improvements has the AP implemented after the bomb threat source?
Well, we don't really publicly talk about our security systems, but I would suffice it to say everyone is well schooled in it and knows what they need to do to protect sources, and protecting sources is crucially important to us. But we don't. I'm sorry, we don't really publicly talk about what actual methods we use. But I'm well versed in all the ones we've discussed here.
I do think that that they've, from what I hear, they've made substantial efforts. And just as one small example, if you had checked before Snowden, before this subpoena case became public on the public key servers, I don't know that you would have found any AP.org email addresses on there, and there are quite a few now.
Hi, Jonathan Hayfitz. I'm a LAPA fellow here this year. A question for Karen or anyone. So with the guidelines, the Attorney General guidelines, other than the enforceability aspect, are there any particular differences between that and the type of qualified privilege that might have been adopted, let's say, in the Fourth Circuit Risen decision that weren't adopted? I mean, what's the gap substantively, if any, between the guidelines and the and what would be a qualified reporter's privilege?
That's a good question. I haven't really done a comparison. I mean, the privilege, the reporter's privilege that you see in the circuits does vary a little bit. I mean, it generally requires that the reporter's testimony or the documents be critical to an investigation, that any alternative sources have been exhausted. I mean, it generally has 2 to 3 to 4 different factors, and it varies a little bit among the circuits. And those factors are in the guidelines as well. The critical difference, of course, is that if you have a shield law, or if you have reports privilege that can be actually adjudicated in court, if a judge can get in and be involved, then that's the critical difference. Under the guidelines, if the Attorney General decides to bypass notice because notice would impair an investigation, that's where it ends, and you don't bring in the court system at all.
I have one thing to say about this, because you brought up the shield law. So I'm not a lawyer, and I definitely don't represent any news organization, but I personally am I'm not for shield law. I think that it would probably do more harm than good to have a shield law, because it would be necessarily so qualified that it would actually undermine the sort of high political cultural threshold we already have right now against taking extreme measures against reporters, either investigative tools or prosecutions. That's to say, everyone understands the Espionage Act is absurdly overbroad and opaque, and Congress has never squarely faced the question, what should be allowed to be published, what shouldn't, what should be privileged against compulsion in court, what shouldn't be. If it does so now, I think the number of subpoenas is going to go up, and I think the ability to defend against those will go down, because Congress will have actually established a standard, and the standard will not help in the cases where we really care, which is when we have a very sensitive story.
Hi, Liza Guettin from the Brennan Center. Just very quickly, Bart, you said that in all the espionage cases thus far, the person prosecuted was a government official who had leaked information. That's not exactly true. There was the 2006 AIPAC case where the prosecution was brought against 2 lobbyists for AIPAC who received information from a government employee, and then they were prosecuted for further disclosing the information. That prosecution ultimately kind of fell apart, but not before the judge issued an opinion saying, yes, the bar here would be very high, but there is a bar and the prosecution could go forward. And so that's disturbing, because it opens the possibility that somebody, a journalist, for example, somebody not the government employee, could be prosecuted.
As you, I'm sure, know, but maybe not everyone here does, there was a fantastic brief written in that case in defense of the 2 lobbyists by Viet Dinh, who was a principal drafter of the Patriot Act, and saying that the allegations against these 2 lobbyists were indistinguishable from what every reporter does every day in Washington, and what lots of policy officials do as well, which is that they meet and they talk about what they're hearing and they trade information. That's the currency of Washington policymaking. And the point is that the author of the Patriot Act was saying, if you do this, then you're declaring open season on reporters. It's quite interesting.
I wanted to ask actually all 3 of you a quick question, which is, and it's hard to ask about something that doesn't happen, but this is a question about what doesn't happen. For Barton and Karen, how many journalists are just not reporting in this area because they don't want to go through, actually, Bart, what you went through, or what your reporters did? In other words, how much is this deterring people from even getting into this field to begin with? And the parallel question to Matt, given the prosecution of leakers, is how much did this change the culture in the agencies, where people who might have talked outside the agency, just because sometimes it's useful to get outside the bubble and get some other perspective, stopped talking outside the bubble because they were very afraid they were going to cross a line and be prosecuted for leaking. So this is all about the conversations that didn't happen.
To me, the cost is not what you're describing. Look, I burned a huge, huge amount of time and effort in the past 2 years, trying to adopt ever tighter security measures for how I maintain my material and how I communicate with people, and B, sort of, there have been times when I would spend hours a day with our legal team, and can I do this and can I do that, and what are the risks and benefits here, and it's a huge burden on my time to spend more and more time doing that and less time actually being a reporter and finding stuff out. I doubt strongly that there are a lot of reporters who are deterred from going into reporting hard stories because of this. I'm not a martyr. I have not faced any great consequences. You know, there's been lots of nice things said about me in my work because I did the story. So I think the incentives would be, sure, I would like to do stories like that. They're hard.
I haven't come across any hearing about any reporters being deterred from taking on this type of story, these types of stories. I mean, we definitely have more safeguards, better practices, everything in place to help that through, but I haven't heard of any deterrents.
Yeah, just on the reporter side, if you measure the number of reporters who called me when I was in office constantly about things, people like Barton and his colleagues, then there's still plenty of reporters working these beats. But on the inside, yeah, I think analysts are concerned. I mean, I don't think they're concerned about being prosecuted. I think they're concerned that they'll see a report in Washington, they'll see someone, or they'll be called by someone, and they'll be asked to actually brief. We had many instances where we brought reporters in, we gave them background briefings by our lead analysts, the young people who are the best people on these subjects. They might be 25 years old. And I think they're mainly concerned about talking about something that's classified, slipping into saying something that was classified when they shouldn't, because they live and work and breathe in a classified environment, and trying to discern what's classified and what's not can be kind of tricky. So, I mean, that's not really, a deterrent for them, but I think it's a real concern. I mean, at the end of the day, the guys like the bomb tech at the FBI bomb tech, I don't have any real. It doesn't bother me, and I don't know, maybe I'm alone in this room, but it doesn't bother me that he was prosecuted and is serving a 3-year sentence for leaking that information.
Yeah. Yes. You have to identify yourself.
I'm Erin Clark, a member of the Tor Project, and I currently work at Slick Media and with The Intercept as a security engineer. And I actually wanted to address your point, which is that I think with the journalists I work with, their ability to, their technical ability to handle information of this nature and also understand it to a much greater degree has actually, I think, increased the amount of people who want to do the reporting and who are able to do so, and has increased their desire to receive information like this. I can't actually report on their actual reporting abilities, but I know their technical abilities have increased to such a degree that they're not deterred by it at all, and perhaps may be going the other way.
That's great. Well, thank you so much. I think we're nearing the end of a long day.